Welcome back to Privacy Engine's podcast series that looks at international data protection legislation, the podcast where we break down the world of data privacy law so you don't have to. I'm your host, Maria, and I'm joined as always by my co-host and data privacy expert, Katie. Good to have you back, Katie.
Thanks, Maria. It's good to be back. Today's episode is the first of a three-part series on the United States because the United States has quite a multi-layered landscape when it comes to data protection, and it really needs a bit more deep treatment, quite like the UAE. When people think about data protection law globally, the GDPR often comes to mind. The Indian DPDP Act is also quite quite to the forefront right now because, as we discussed in previous episodes, it is quite unique in the global landscape. But the US is an interesting one because it's quite fragmented in comparison to the GDPR and the DPDP. The GDPR, which governs Europe, and the DPDP, which governs India, which is one of the most populous countries in the world. So, because again of the population of the US and its technological reach, their data protection landscape has practical implications for many organizations who operate across borders.
Exactly, yeah. And I think a lot of our listeners, whether they're based in the EU, in India, the UAE, like we've looked at before, will have US operations. So this hopefully will be relevant to them. They either have, data transfers to the US or they have US customers. But, definitely, it's definitely worth having a deeper dive into the US because it has quite a rich history, I think, in terms of privacy. They don't really call it data protection, they call it more privacy over there. So I think it's warranted. A three-part series is warranted, and it's designed to give you to give our listeners a thorough grounding in the current, landscape of privacy in the US. In part one today, we're going to cover the history of US privacy law, and I think it's riveting. I'm really looking forward to jumping into it. Why there is no comprehensive federal law, and the key federal sector specific statutes that practitioners encounter on a day-to-day basis. So just because they don't have a federal privacy law doesn't actually mean to say that they don't have any privacy obligations in the US. Then in part two, we'll turn to the state specific laws landscape. California is the most significant state there in terms of their data protection or their privacy laws. And then there's a growing patchwork of state privacy laws, individual rights, children's data, and how the FTC or the Federal Trade Commission operates as America's de facto privacy regulator since the 1990s, really. And then part three, probably our most internationally focused episode, we'll go deep into the transatlantic transfer story. And I love this story. I've been following it for like 20 years. The EU-US relationship, it started with Safe Harbor back in the Clinton era, the Schrems decisions, and then the Privacy Shield, and exactly where we are today with regard to the data privacy framework. There's an awful lot of history there and a lot of interesting discussion as well. So I can't wait to jump in.
It is, yeah, I agree.
Okay, so the first question we're going to look at today is the state of data privacy law in the United States. Why is it so different from from the rest of the world? So, Katie, let's start with the big picture. For our listeners coming to the US privacy law for the first time, what is the single most important thing they need to understand?
Thanks, Maria. So, the single most important thing is that the United States do not have a single comprehensive federal data privacy law, unlike the EU's GDPR and the Indians' DPDP Act, even Brazil's LGPD and Canada's PIPEDA. The US is a bit more of a patchwork, as you said before. The federal statutes are sector specific. They have a growing number of state laws. As you said, the Federal Trade Commission does the enforcement in the privacy sphere under general consumer protection powers, which, I mean, data protection is consumer protection as well, but it is more than that at the same time. Um, Out of all the jurisdictions we've covered so far, it reminds me of the UAE landscape the most because both of these countries are federal nations with internal states or emirates, so I think it's a good comparison to draw. So what you have with the federal level is a collection of laws that target specific sectors or specific types of data. We'll talk about a few of them later, but some of the important ones is the Health Insurance Portability and Accountability Act. It covers health information, the Children's Online Privacy Protection Act for children's data, and the Gramm-Leach-Bliley Act for financial data. So those are the three main federal ones. Outside those specific sectors, there is no floor of privacy rights for individuals. There's no baseline rights for individuals, no comprehensive obligations on companies who process any type of general consumer data. If even not all company, well, I'll touch on that later, but there isn't even an obligation on all companies that deal with health data. Um, so
But
what?
HIPAA, I would say HIPAA is the most known. So you
Yeah,
mentioned HIPAA there. I think a lot of people have heard of HIPAA, you know.
yeah. For it is. I mean, even I had heard of it here and there before coming into the data privacy sphere, but
And it's quite strict in certain areas. It can be very strict in terms of protecting health personal data.
it can be, yeah, it can be. I also like the Gramm-Leach-Bliley Act. They both have some controls and familiar obligations that we've seen before.
Yeah.
So,
Um, and so why has the US taken such a different path compared to basically the rest of the world? Like, is it purely political or is there something more structural going on, do you think?
I mean, I'd say both because, like, structurally, the US has a strong tradition of sector-specific regulation. They they seem to respond more to kind of harms in the moment rather than a proactive approach. So it's more of a reactive model that kind of has produced protections in place for certain kind of sore spots, a bit like kind of whack-a-mole.
Yeah, yeah.
But
Unlike the GDPR, which is a horizontal act, a
yeah,
horizontal regulation. Yeah.
it's the opposite approach there. Um, each side of the Atlantic. There also is political pressure. I mean, we've kind of talked about it here and there, but there is powerful companies in America that you can't ignore. There's a lot of presence from technology and data intensive industries that resist comprehensive federal legislation. And you can see that these companies have so much strength and influence even in Europe and other countries. Like, imagine the pressure that's in the USA.
US, yeah, because they're usually US based or they're US owned organizations, these big tech companies like Google and Meta and
Yeah.
Amazon.
So there's also the fact that it is a federal nation. There's kind of a bit of a give and take between the federal and state governments, in, well, what should be given to the state to rule and what should be within the remit of, you know,
Yeah.
within purely federal remit, which, we might not be that well versed in that particular type of politics.
I agree because it's very different in Europe. We get directives from Europe, but we have our own body of law in each nation as well. Do you know what I mean? So even though Europe oversees all the member states, there's not that kind of competition between the federal and the state level.
Yeah. And I'd say there's so many dimensions to it, in my opinion. And like another thing to consider is also what we have said before is the cultural element of the United States. Like, they're very free speech centered. Like they really value free speech and the free flow of information and commercial innovation. Like that's values that they hold close to their heart.
I agree.
And
Yeah. And that
whereas,
I think that's where the fundamental difference between Europe, I think it's even ideological. Do you know what I mean?
yeah,
So Europe, because of the Second World War, because of, how personal data was used in the Second World War to identify people's religion, it's very close to our heart, data protection, so that will
yeah,
never happen again, kind of thing. Whereas in America, it's all about freedom of speech and innovation, like you say, and freedoms, and ensuring freedoms as opposed to protections.
and that kind of culture also bleeds into their constitution. So in their constitution, they do not have a direct right to privacy the way that we would. So it
Yeah,
it
true.
comes through, it's a bit political, it's a bit structural, it's a bit cultural, but I mean, it makes sense for them.
I agree. And I think in the third episode, we'll dive deeper into those kind of differences between Europe and the States. There's a long history there of
Yeah.
like the differences.
So I think that's kind of an overview of what the data privacy landscape looks like and why it is so different. I think I'll move on to your question, Maria, which is what is the history of US privacy law and how did they get to where they are today?
So I love this part because I studied this for my PhD. So I looked into the whole history of where privacy came from. And you could argue that it started in the 1970s, but in my opinion, it really started back in 1890 with Louis Brandeis and Samuel Warren's published landmark Harvard Law Review article, The Right to Be Let Alone. It was all about when photography became kind of mainstream back in the late 19th century. They were worried about the press actually taking photographs and it invading people's personal life, private life. And so, that was the first kind of real argument for privacy in the United States. And it has existed and is lasted since because I remember I studied it in my PhD as well, the right to privacy. Then you had in 1914 as well the establishment of the Federal Trade Commission in the United States, and that became in the 1990s that became very instrumental when protecting the rights of individuals' privacy because there was no kind of law to protect it. So the reason why the FTC was initially established was to outlaw unfair or deceptive commercial practices. And it laid the groundwork for the agency that would eventually become the closest thing to the US that the US has to a privacy regulator. Then you move forward to the 1970s, and the right to privacy in the US begins with not necessarily a legislation, but it began with ideas. So in 1973, the US Department of Health, Education and Welfare published another landmark report called Records, Computers and the Rights of Citizens. That report gave the world the first instance of the Fair Information Practice Principles, or what we now call FIPS. And these were a core set of principles about how personal data should be collected, used, shared, secured, and subject to individual access and correction. So they kind of make the foundation for many laws now in our modern day, especially the GDPR. So the initial principles were one, no secret record keeping systems. So that should be outlawed. Everybody has the right to know what data is being processed about them. They have the right to limit the use of their data. They have the right to correct, and they have the right to security and reliability. So they were the first five FIPS. And, as you can see, these principles have influenced virtually every US privacy law ever since. And they have echoed internationally as well, because if you look at the OECD's 1980 privacy guidelines and decades later, the GDPR. that you can see there's the basis there on which legislatures have built. And then in 1974 came along the Privacy Act, which was the direct legislative product of the moment. It was passed in the shadow of the Watergate scandal. So the Watergate scandal caused Richard Nixon to resign. In 1972, operatives linked to Nixon's re-election campaign broke into the headquarters of the Democratic National Committee. And it wasn't necessarily the break-in that caused the scandal. It was the cover-up that followed that caused the scandal. So, they tried to cover it up so much that it brought down the presidency. So after that cover-up, the Nixon administration became synonymous with the abuse of government databases and surveillance of political opponents. So as a result, the Privacy Act was established, and it established a code of fair information practices for how federal agencies handle personal data. When it was first published, it was seen to be the American Bill of Rights on Data, but it applied only to federal government agencies and not to the private sector, and it had significant structural weaknesses. There were broad exceptions for national security and law enforcement. What we have now, FISA today, it still existed back then. The CIA and so on still wanted to gather as much data as possible, in terms of like protecting national security and so on. So it kind of weakened the law as a result. And it had the act had no meaningful enforcement mechanism, and a requirement that violations be intentional and willful. And how do you interpret that, or how do you even prove that violations are intentional and willful? So, in the words of the 1976 Law Review, the act became practically unenforceable. And so a commission created by the Act itself concluded in 1977 that it had not delivered its intended benefits. Then through the 1980s and the 1990s, Congress continued to, put into force reactive and sector-specific laws and acts. For example, this is quite a funny one. The Video Privacy Protection Act of 1988 was famously triggered after a reporter obtained the Supreme Court nominee's Robert Bork's video rental records during his confirmation hearings, and they published it in a Washington newspaper. Now, it wasn't the fact that he had been watching anything, all his videos were mundane and kind of mainstream, but what caused outrage was the fact that his records were so easily accessible and so easily published that they came up with a law called the Video Privacy Protection Act. So it's a remarkably specific law for a remarkably specific scandal. So you can see, like you said, Katie, they come up with laws in the States for basically on the back of scandals, So if something reaches national news, then they feel like they have to act and put something in place to protect from that scandal, So
Yeah.
the Electronic Communications Privacy Act of 1986 extended the wiretap restrictions that we saw from the Nixon scandal, and it extended them to electronic data. And then, like you said, in 1996, we have the HIPAA law that governs health information. And then in 1998, along came COPPA for children's protection, the protection of children's data. So then alongside this patchwork, you have the FTC, the Federal Trade Commission, which quietly stepped into the vacuum when the internet came along and it became obvious that somebody needed to protect personal data online. So since the late 1990s, the FTC has used what it calls Section 5 authority to prohibit unfair or deceptive acts and practices in commerce. So under that umbrella, they can stop organizations from invading privacy as well. So they're allowed to bring enforcement actions against companies that mishandle consumer data or violate their own stated privacy policies. And the result of this has been a growing body of consent decrees and settlements that functions almost like a regulatory framework, even though Congress never designed it to be one. The FTC has extracted major penalties from companies like Facebook, Google, Twitter, Amazon. For instance, the Cambridge Analytica scandal, and I'm sure you know about, I think most people have heard about the Cambridge Analytica scandal in 2019 and Facebook's, mishandled political data, and it influenced the elections in the US. The Federal Trade Commission then stepped in and won a settlement against Facebook for $5 billion. So that was the most significant settlement at up to that time for misuse of personal data.
Okay.
Yeah.
That's
And there was another one as well with Amazon Prime, which was in 2023. So the Federal Trade Commission took Amazon to court because they were using dark patterns to try and get people to sign up to Amazon Prime, and they proved that was true. And then, as well as using dark patterns to get them to sign up, they were making it extremely difficult for people to unsubscribe, and that was proved. The FTC proved that in 2023. And I think that was $175 million of a settlement as well. So you can see, it's very patchwork and it's very reactive, like you said, to scandals and to specific situations.
well, they haven't changed anything because I signed up to Amazon Prime
Oh,
and
really?
because I wanted to buy something and the discount or delivery was so much better with Prime. And I thought, well, I will use this. And then a couple of months went by and I realized I'm not using this. Like, I need to cancel it. And it was so difficult to
Really?
cancel. It was so difficult. It was actually the vein of my life for a while, for a bit.
Really?
It could have been me. I mean, that was in 2023 that they made that decision, but I found it that you had to um
You had to search to unsubscribe.
you had to go through a couple of hoops.
Yeah, yeah. And when was that? Was that later than 2023?
It was recently, maybe it was last year.
Okay. Yeah, so they haven't really learned anything.
Yeah, so it's just funny that you say that because
Mm.
I got caught.
Mm. Interesting. Yeah.
Yeah. Um so did people ever begin to kind of push for a federal privacy law that actually covered everything? And if they did, why is it still not the case?
Yeah, I think they've been pushing for a while, you know. The push for a comprehensive law has been recurring since at least the mid 1990s, like we said, since the advent of the internet. But again, I don't think there was ever a real appetite for it. All the more serious attempts have been blocked by the same kind of cluster of structural and political obstacles. And I think a lot of people think it's just bureaucratic red tape, but the truth is Congress has been deadlocked on this for decades. There are major disagreements in across the political parties about privacy. So I think the most important one is the private right of action. So basically this boils down to one question. If a company mishandles your data, are you allowed to take them to court? Are you personally allowed to take them to court? The Democrats and consumer advocates believe that this should be the case. You should be able to take them to court and hold them accountable. On the other side, the Republicans and many business groups say no, and they're worried that, like, if a law comes into place, there'll be an avalanche of frivolous litigation that hurts businesses. And then you have the whole issue around federal preemption, which is all about, like we said, the state versus federal power. Um, businesses are pushing for a single national rule because it's easier for them. Because, like you say, we see a patchwork now coming up across the states. But then there are states like California, which already have really strong privacy protections. And they're worried that if a federal law comes into place, then it will water down their existing state law. So you see that kind of tug of war going on between, state and federal requirements or obligations. Um, and then the whole thing of a commissioner, who becomes the data protection or the privacy commissioner. So we have, we have the Federal Trade Commission, um, but they don't have enough powers like a DPC in Europe would have. So do you make them more powerful, or do you create an independent privacy commissioner? So all these kind of questions have to be looked at. And then added to this complexity, for the last 20 years, tech and data heavy industries have been incredibly effective at using the sheer complexity of these issues to slow everything down when it gets to, to federal level. And then with the lobbying, they manage to water things down as well. So, or even just simply bury the legislation and make it so slow and make it so difficult to get it passed that it just gets lost somewhere. Um, and it's not just the tech giants, it's small businesses as well that don't want these types of laws to come into place because they're worried about a whole new set of federal rules making business too expensive for them. Um, and then, the politics on top of that, it's not simply about left versus right. Um, the whole landscape of privacy is quite messy. You've got some conservatives who want strong personal property rights for data. Then you have some Democrats who are legitimately worried about new regulations crushing small businesses. And so yeah, it just seems very kind of complex. I think that the best example was in 2024. There was an act called the American Privacy Rights Act, or what we call APRA. And I think that was probably the most serious attempt we've seen in years. And it did have bipartisan support, and it actually got passed by the Committee on Energy and Commerce. But it actually then, once it was supposed to go from that committee to the House of Representatives, it got lost. So, it was blocked on the way, and it never got a vote. It never got to actually be voted on by the House of Representatives. So anyway, let's move on, Katie, and let's look at what are the federal sector-specific privacy laws, and what do practitioners need to do in order to comply with all of these?
Thanks, Maria. I'll just go through a couple of them, of the most important, most pivotal ones to be aware of. And I'll start with the HIPAA, the HIPAA, the Health Insurance Portability and Accountability Act of 1996. It is the most widely known US privacy law, and it's for health information, specifically protected health information with the abbreviation PHI. And what that means is any individually identifiable information relating to a person's health condition, healthcare provision, or their payment for care. So they do interpret that broadly. They include billing records, appointment histories, and anything that can be linked to an identifiable individual. In relation to privacy, it kind of has three main aims. First of all, to protect and enhance the rights of consumers, because people who receive healthcare in the United States are also consumers, by providing them access to their health information and controlling the inappropriate use of that information. Secondly, to improve the quality of healthcare by restoring trust in the healthcare system among consumers, healthcare professionals, and organizations that are involved in the delivery of the care. And thirdly, to improve the efficiency and effectiveness of healthcare delivery by creating a national framework for health privacy protection that builds on state efforts and the efforts of individual organizations. Those who are subject to HIPAA need to disclose the minimum, so it's data minimization, basically. Um, they need to consider the minimum amount of PHI necessary to fulfill their purpose of processing. And they also need to implement certain safeguards in relation to the data. That includes training staff and designating a member of staff who has ownership of the privacy of health data. So, who does it apply to? They have kind of two terms of who it applies to, which is covered entities, and that includes healthcare providers, health plans, healthcare clearinghouses, and then also to these covered entities, business associates. So that's the vendors and the contractors who would handle health data on their behalf. But it's quite interesting because it doesn't apply to all health data. It just applies to the health data processed by these covered entities and their business associates. So it doesn't apply to employers receiving health information in their capacity as employers. It doesn't apply to life insurers. It doesn't apply to consumer health products like wearable devices, like, Apple Health or all that kind of health data that an Apple Watch or a Fitbit might record. So there's a lot of health
Hmm.
data out there that is not regulated.
And it's not protected
Yeah,
under any law in
yeah.
the States.
Well, not by HIPAA anyway.
Yeah, and insurance companies, that like life insurance, that surprised me actually.
Me too. Yeah. That I think it's one of the shortcomings of the HIPAA Act,
Hmm.
to
And
be
as
honest.
well, like you say, with all these Fitbits now and everything like that, I mean, they're very recent and they're very, very sensitive data as well. It's very precise about tracking your physical, health on a daily basis, and that's not protected.
Location, even
Location as well,
not
yeah.
just health data, like it's a lot of data that does be in those devices.
Hmm. Yeah.
Um, so it's a
And
big, it's a
and it's not
patchwork.
protected. Yeah. Yeah.
So that act is enforced by the Office for Civil Rights, and for their penalties, it's in four tiers. And there's a word here. There's one of the tiers. The words will remind you of what you were talking about earlier. So the first tier is an unknown breach, which seems to be like a purely innocent or ignorant breach. The second tier of breach is where there's reasonable cause.
Hmm.
The third tier is willful neglect that has been efforts have been made to correct it. And the fourth tier is willful neglect that has not been corrected. Um, their minimum fine on the unknowing tier is minimum fines of $100. Maximum for a single fine on the highest tier, they have an annual cap of $2 million. So
Wow.
throughout the tiers, that's the range of fines you could get. And
They take it very seriously as well, because I remember I worked with a one of my clients was an American hospital, and one of their nurses accessed a medical health record of somebody that was famous, and she had no reason to access that because she wasn't assigned to that individual, and they actually dismissed her as a result because she had violated HIPAA.
that's so interesting that you mentioned that, because I actually had noted down as my final point on HIPAA was that is one of the main breaches and common causes for fines, which is accessing records that it was not necessary to access or within the description of the job function to access.
Hmm. Yeah. And that nurse actually lost her job. So it went
God.
to a committee within the hospital, and I think maybe there was a review, there was, an investigation, and the decision was that the individual would be dismissed. So they take it very seriously. Yeah. Yeah.
So then that's for health data. Then there's for children's data, which is the COPPA, the Children's Online, or the COPPA. I'm not sure how to say that out
Hmm.
loud, but the Children's Online Privacy Protection Act. It's from 1998 and it went into effect in 2000. So it requires parental consent when processing data from children under 13 online. It applies to operators of websites and online services directed at children or those with actual knowledge they are collecting children's data. And this even applies to children outside the US, so long as they're a US company. So that's kind of nice.
Yeah.
It's
So how
children.
do the social media platforms get away with it?
Yes, good, very good question, Maria. My next. Platforms, they don't want that burden. They do not want that burden. So they simply declare themselves as not directed at children. And you know that confirm that you are over 18. That's
Hmm.
why they require people to say, I'm over a certain age.
Yeah.
Because then they say,
13. I think it's 13,
13 is
isn't
our
it?
line, yeah.
Yeah.
So the line from COPPA was actual knowledge that they are collecting children's data. So then, effectually they can say, well, we had no actual knowledge, because
Hmm.
we asked them what age they were. And,
And they checked the box.
everyone's completely honest, so it's class.
Hmm. Yeah. Yeah. But I think they are thinking about raising that to 16, aren't they? I think there's been discussions
Okay. Well,
bringing
that
it
would
to,
that would be good.
that
I
would make it
mean,
much better. Yeah.
you're still very young. When you're
Those
16,
3 years, yeah, make a big
yeah,
difference, I think.
it's a vulnerable years too.
Yeah, absolutely. Yeah.
So yeah, they kind of have a bit of a workaround, but the enforcement, again, the FTC, they're doing all the legwork here.
Yeah,
The
fair play.
enforcement has been significant. YouTube uh, had a 170 million settlement um,
Gosh.
in 2019, which, I mean, that was a long time ago now.
Yeah. Yeah, 7 years ago. Yeah.
But there has been critiques that it's inconsistent enforcement and, it's not
Hmm.
that robust for children.
Yeah. And I think I may be wrong, but I think there is kind of congressional interest in strengthening COPPA, and and I know that if some proposals have been introduced to increase the age of from 13 to 16, but nothing has really been enacted
Okay.
yet. But you never know. Watch this space. Hopefully, they will get that past the line.
Hopefully, I mean, I think protecting children and young people is something that shouldn't
Absolutely. Yeah.
have, like, nobody should be. I don't understand why anyone would argue against it.
Absolutely. Only for money, I think basically that would be the argument. It's too profitable, but hopefully the tide is turning.
So I move on again to the GLBA, the which I actually didn't know that much about this before I done my research, but I kind of like this one a bit. The Graham Leach Bliley Act of 1999.
Hmm.
It seemed to have been privacy by accident. It wasn't like the main idea of this act. The idea was to repeal certain restrictions that came in the Depression in America, to allow banks, investment firms, and insurance companies to merge. So it was kind of in recognition of what this would allow financial institutions to do, that, they would have kind of a window into so many different aspects of people's lives that they put in the privacy provisions into it again, like
To avoid
this wall,
profiling,
the
basically,
scandal.
financial
Yeah.
profiling, almost. Yeah.
They didn't just react to a scandal this time; they actually foresaw it. So
Good. That's good.
yeah, that's why I like this one. I feel like you don't hear about it that much.
Yeah, yeah. I hadn't heard of it before we did our research, like you say.
Um, it applies to financial institutions and it's very broad. It's not just banks and insurers, also mortgage brokers, payday lenders, financial advisors, debt collectors, even pawn shops.
Okay.
It, sorry.
Pawn shops are interesting because that would even doing business with a pawn shop would imply a certain financial status. Do you know what I mean? So that's
Yeah,
interesting. Yeah.
it really covers all bases. Well, all, angles of
And
someone's
you
financial
and you
profile.
know how we mentioned insurance companies not being covered by HIPAA, but they are
Mhm.
covered by this law. So maybe that gives some sort of protection to the individual
Yeah,
in terms of privacy.
for sure. And it also is a good representation, again, of the culture element that the financial information has more protection than the health information,
Yeah,
broadly
yeah,
speaking. So
true,
it's just,
true.
um, there's three main, I won't go into that much detail, but there's three main components. They have the financial privacy rule, safeguards rule, and pretexting rule, which is about social engineering. Um, but I'll just touch on the privacy one. So there's five kind of aspects of it. They have to designate a privacy coordinator to ensure that controls are in place to safeguard data.
Hmm.
They have to complete a risk assessment to areas that could compromise privacy of personal data. They have to implement logical and proportionate controls based on the risk assessment. They have to perform robust vendor management. Vendors need to have contracts, adequate certifications, and assurances that they have appropriate controls and record any breaches or security incidents. So, a bit of Article 28 there. Um,
So it's very
and
similar to like a DPIA, risk assessment and then vendor assessments that we see in the GDPR.
yeah, and they also need to have an ongoing process for reviewing and updating security controls.
Okay. So
So
very similar.
I like that act. Like it's very familiar. Though
Hmm.
going through those five, it's like, well, I've heard that before.
Yeah, absolutely. Yeah, very good.
Um, so that's the three main ones. There's a couple of other ones I'll just touch on really quickly because you you could talk about them all day and we're
All
trying to cover
day.
everything.
Yeah.
Um, but so they have the Family Educational Rights and Privacy Act. It's one of the oldest federal acts they have, and it's related to education records of those under 18.
That's more protection of children's rights, children's privacy rights then.
Yeah.
Yeah.
So it's basically the right to access, request, correction, and, disclosure of educational records to third parties. I think the disclosure of education records to third parties was the main aim of this act that they wanted to capture that, at the end of the
Okay.
day, it's the parent who
Hmm.
has that right to consent to disclosure of their children's education records. So it's an old act.
So it came
It's
in 1974, so it is quite old, isn't it?
yeah, it
Mm.
was it was when everyone had paper records. So in the modern time enforcement has been strained, but it's one to note. I mean, it's quite a unique one.
Hmm.
Then they also have the Electronic Communications Privacy Act of 1986, which is governs the government's access to electronic communication. The wire trap, I think you mentioned
Hmm.
earlier, so we know about it already, but yeah,
It was a follow-on from the Nixon scandal, wasn't it? Yeah.
yeah. So yeah, there's even more than this. I mean, you could probably uh, go on for a long time talking about all the random sector specific federal
Hmm.
laws. They have Cable Communications Policy Act, they have Video Privacy Protection Act, as you said,
Yeah.
Driv- Privacy Protection Act, after a stalker obtained a victim's address from the DMV.
Oh,
So
wow.
it's so reactive.
Yeah.
It's
Yeah, if it was more general, it would protect more kind of records. Do you know what I mean?
yeah,
People's more personal records. Yeah. Not just the driving record, do you know?
yeah. And the end result is it's quite a complex privacy landscape because you have to be very careful thinking about what type of data am I processing? What type of entity am I? Like, you might think that the HIPAA Act applies to all health data, but it actually just applies to covered entities and
Hmm.
their vendors, you know?
Yeah.
It's stuff like that. Yeah.
Yeah. So it's complex and yeah, industry specific and state specific, and sometimes even federal, you know, federal specific. So yeah. But I think we have kind of a very good grounding now. So we've done kind of the history and the structure of the US privacy law. I think what strikes me is how much of a patchwork it genuinely is. Um, and I think it's not been done deliberately, but it's been a consistent sequence of choices that's been made to create this patchwork because of, the way Americans live, their principles, their ideology, and so on. I don't think it's just a historical accident. Um, because, we look at 1974, 1973, we had, they started off with fair information practice principles, so they had these ideas, but I think it's been an active choice just to kind of be industry specific as opposed to like a blanket protection act like we see in Europe.
So I think another takeaway from this episode is that just because there is no comprehensive federal law doesn't mean there are no laws or obligations. You still are going to have to pay attention to what the nature of your organization is, who you target, and what kind of information that you process because the obligations are there. They're just fragmented, and as we highlighted, some individuals have can lose. You can have fines. There's some criminal penalties, and even from your story, that individual who lost their job.
Yeah, exactly. Yeah. Yeah. So like you say, just because there's not like an industry agnostic law cutting across, all of the various different industries, it doesn't mean to say that you don't have obligations. You definitely do. Um, so in our next episode, part two, we'll turn to the state law landscape. And that's, again, it's quite a patchwork, especially in the last 5 years, I think. California, with its CCPA, kind of started it off, and now they have the CPRA that we'll get into in more detail as well. And then there's a growing list of state comprehensive privacy laws that we'll have to look at as well. So, how individual rights compare to the GDPR, that'll be an interesting discussion. How children's data is being regulated at a state level, and what are the FTC, what is the Federal Trade Commission actually does in practice? Like, it's America's de facto privacy regulator, but we'll get into more details about what it actually does. So make sure to join us for that.
And for our third part also, where we'll be covering the transatlantic data transfer story, which has a bit of conflict.
For sure.
The Safe Harbor Agreement, the Schrems decisions, the Privacy Shield, and the current data privacy framework. It's a very interesting story, and it's important for anyone who's moving data between Europe and the US.
Yeah, I'm really looking forward to that one as well because it's a really interesting story, I think. And again, it involves a lot of conflicts really, but at a kind of a very high level. So yeah, it'll be interesting to get into it. So, thanks for that, Katie. Thanks for your time. And until next time, take care of your data, everybody.
And each other.